This is a brief introduction to international criminal justice. And my name is Kingsley Abbott. I'm the Director of Global Accountability and International Justice at the International Commission of Jurists. I'm originally from New Zealand, and my background is that I started my career as a domestic prosecutor and defense lawyer, and then I worked for a number of years at the United Nations in Cambodia as part of the investigation team investigating atrocities committed by the Khmer Rouge. Then I worked as a prosecutor at the Special Tribunal for Lebanon in The Hague, which was investigating the assassination of the former Prime Minister Rafik Hariri and other related cases. And over the past 7 years, I've worked with the International Commission of Jurists, and I've been mostly based in Asia during that time. During this course, you'll hear a lot about the Minnesota Protocol, and I was part of the expert team that helped the former Special Rapporteur on Extrajudicial Killings, Christoph Haynes, develop the Minnesota Protocol. And since then, I've been involved in holding a number of trainings on it around the world. So let's begin by talking about international criminal justice. And I think that the first point to make is that international criminal justice primarily concerns itself with the liability of individuals, rather than the rights and obligations of states, which is one of the main focuses of international law. And the international criminal justice system as we know it really had its origins in 1945 at the end of World War II, where in Germany and in Japan, the Allies, the UK, Russia, America, France, put on trial the leadership of the German and Japanese forces for their crimes. And these trials are celebrated for establishing the principle that crimes against international law are committed by individuals, not by abstract entities. And it was also the first time in international law that genocide was indicted as a crime. And a significant amount of later legal development looked back at these trials for precedent. However, there wasn't much progress in international criminal justice for another 40 or 50 years because of the Cold War, which, as we know, was an ideological struggle between the US on the one side and its allies, and Russia and its allies on the other side. But when the Cold War ended with the fall of the Berlin Wall in 1989, this ushered in a new period of international cooperation, which provided a great base for international criminal justice to progress further. The next major milestone with international criminal justice was the establishment of the International Criminal Tribunal for the former Yugoslavia, the ICTY, and the International Criminal Tribunal for Rwanda, the ICTR, both created by the UN Security Council in response to atrocities being committed in those countries in the early 1990s, including allegations later found to be proven of genocide. So the ICTY was established in 1993, and before it ceased to exist in 2017, a total of 161 persons were indicted. And it made many precedent-setting decisions on genocide, war crimes, and crimes against humanity. The ICTR, on the other hand, was established in 1994, and it was located in Tanzania. And before it closed its doors in 2015, the ICTR indicted 93 individuals. And like the ICTY, it also made a significant contribution to the body of international criminal and humanitarian law. And whilst both the ICTY and the ICTR had closed their doors, today their work is continued by something called the International Residual Mechanism for Criminal Tribunals, which carries out a number of closing functions, looking for some of the final fugitives of the ICTR and handling appeal proceedings and retrials. Turning now to the International Criminal Court. The International Criminal Court, or the ICC, which is governed by the Rome Statute, is significant because it is the first and only permanent treaty-based international criminal court established to fight impunity around the world. The ICC is an independent international organisation. It's not part of the UN system, and it is based in The Hague in the Netherlands. And its founding treaty, the Rome Statute, was supported by 120 countries in 1998, And the Rome Statute entered into force in July 2002 after ratification by 60 states. The ICC has jurisdiction over the most serious crimes of concern to the international community as a whole, namely genocide, crimes against humanity, and war crimes, when committed after 1 July 2002. And each of these crimes is clearly defined in the Rome Statute and other relevant legal texts. And in 2017, states parties to the Rome Statute also agreed to activate the ICC's jurisdiction over the crime of aggression, which is the fourth crime set out in the Rome Statute. Now, the court may exercise jurisdiction over the crimes in the Rome Statute only if they were committed on the territory of a state party or by one of its nationals. But these conditions don't apply if the situation is referred to the prosecutor by the UN Security Council, whose resolutions are binding on all UN member states, or if a state makes a declaration accepting the jurisdiction of the court. The ICC is intended to complement rather than replace national justice processes. It can only prosecute cases if national justice systems don't carry out proceedings, or when they claim to do so but in reality are unwilling or unable to carry out proceedings genuinely. And this fundamental principle is known as the principle of complementarity. I think it's important to note that the ICC in some ways was created against all odds, and some would argue the current international climate is such that it may not be created or may not have been created today. And at the time, the world's major powers were opposed to it, and some major powers are still opposed to it. While most of Europe and Latin America and Africa have joined the ICC, big gaps still remain in the Middle East and in Asia, for example. And major powers such as China, India, Russia, the United States, they still remain outside of the system. But on a positive note, as of today, 123 countries have ratified the Rome Statute and agreed to be bound by its terms, and the efforts to persuade other states to also ratify the treaty are ongoing. In addition to the ICTY and the ICTR and the ICC, since the 1990s, we've seen a number of other special ad hoc tribunals that have been set up to prosecute domestic and international crimes. Some of them are based in the countries where the crimes took place. Some of them have mixed national and international staff. And examples include in Kosovo and Bosnia and Herzegovina, East Timor, Sierra Leone, Cambodia. And we've also seen a number of domestic prosecutions in states for crimes under international law over the years, particularly in Latin America, which in some way led the way on some of those cases. Let's talk a little bit about some current challenges and trends. Now, the establishment of the International Criminal Court was meant to really be one of the main forces against impunity for crimes under international law around the world, and it has served that function. But today we are still seeing impunity for serious rights violations which amount to crimes under international law. Look at Syria, Yemen, Myanmar, North Korea, China, just for some examples, where we are not seeing accountability. And it's a significant challenge. So one has to ask the question, why does impunity persist in these countries? And often many of the same factors are present. We often see present the fact that states are unwilling or unable to conduct genuine investigations and prosecutions. States have still not ratified the Rome Statute of the ICC. The UN Security Council does not refer the appropriate situation to the ICC in those circumstances. And third-party states that might be willing to launch prosecutions in their own countries, maybe under universal or other extraterritorial jurisdiction, are unable to do so for a variety of reasons, including lack of access to relevant and admissible evidence. And I'll talk a bit more about universal jurisdiction in a moment. But because international justice doesn't stand still, we are still seeing that people and states are coming up with new and innovative responses in the global fight against impunity. And I'll refer to just a few of those trends that we are seeing now. One is that we're seeing the increased use of universal jurisdiction. Now, the principle of universal jurisdiction is based on the notion that the fight against impunity is borderless. And under this principle, states have the option and sometimes the obligation to prosecute criminals or alleged criminals who are located on their territory, regardless of where the crimes may have been committed or their nationality. And universal jurisdiction has received renewed attention in recent years, mainly as a result of the international community's inability to bring about justice for victims of the horrors that were committed in Syria. But now we are seeing more and more Syrians seeking shelter in Europe, and some European states are now launching investigations and prosecutions. An NGO called Trial, which publishes something called the Universal Jurisdiction Review, notes that in 2018 alone, we saw 150 investigations and 17 trials based on universal jurisdiction. And then in 2019, there was a 40% increase in those efforts. The next trend we are seeing is a new generation of UN body-created mechanisms. Now, we all know that for decades, UN bodies have established commissions of inquiry and fact-finding missions for a variety of purposes, including to inquire into alleged violations and abuses of international human rights law, international humanitarian law, and international criminal law. But today, a number of trends are being observed, including that new mechanisms are being created with increasing frequency, particularly at the United Nations Human Rights Council. And their mandates often reflect a greater focus on accountability, including the identification of crimes, the identification of perpetrators, and the collection of evidence. And we're also seeing a new generation of independent investigative mechanisms being created. For example, the International Impartial and Independent Mechanism for Syria, the IIIM, and the Independent Investigative Mechanism for Myanmar, the IIM. And these two mechanisms have specialized mandates to collect, preserve evidence and build case files for use in criminal proceedings in national, regional, and international fora. So really, they are there to plug a gap where a recognition is made that evidence needs to be collected as soon as possible, even before we've identified an appropriate forum for a trial. But we collect the evidence, we freeze it, we put it on hold so that it can be used later when someone requests it. Another trend that we're seeing is a rise of specialist NGOs working with human rights defenders and victims groups. A new category of non-state actors has emerged, specializing in gathering evidence, documenting crimes, collecting testimony, locating suspects. And some of these have come into being because there's sometimes a feeling that some of the larger institutions like the ICC, whilst they're enormously important, sometimes take time before they can become engaged with the situation. Sometimes they are the last to arrive on the scene after months or even years have passed where atrocities have been committed. So some organizations like Eyewitness and an organization like CIJA have set about gathering information, gathering evidence, and supporting prosecutions at the national, regional, and international levels. For example, CIJA, which you can read about online, has about 120, 130 specialist personnel investigating, gathering and preserving evidence, building case files and indictments against those most responsible in countries, particularly in Syria. And they are currently assisting a variety of countries in their domestic prosecution of regime officials. So we're seeing here a new era of the cooperation between the public bodies and private actors, all with the same goal of ending impunity in sight. We're also seeing some legal innovation, and I'll just name 3 different examples. We're seeing legal innovation at the International Criminal Court. An important example is in the Myanmar case, where because Myanmar was not a party to the Rome Statute, many people felt that atrocities committed there wouldn't be able to come under the jurisdiction of the ICC. But the Rohingya, one of the main victims of atrocities in Myanmar, because the result of the crimes that were committed against them included that they were forcibly transferred into a neighbouring country, Bangladesh, the court looked at Bangladesh and said, well, Bangladesh is a state party to the Rome Statute. Maybe it's sufficient under international law if part of a crime or one element of a crime is committed inside a country that is a party to the Rome Statute, that's sufficient for us to have jurisdiction. And so now we're seeing the International Criminal Court investigating the Myanmar-Bangladesh situation, where any crimes may have started in Myanmar but ended up in Bangladesh. Another legal innovation is also related to Myanmar, where we are seeing quasi-criminal proceedings being brought before the International Court of Justice. Now, the International Court of Justice is not an international criminal court. It's concerned with state obligations. But we've seen that the Gambia, a small African country, has brought a case against Myanmar, alleging in the International Court of Justice that Myanmar has violated its obligations under the Genocide Convention, namely that it's committed genocide or it's failed to prevent or punish genocide and other obligations that it has. Now, whilst this proceeding is not criminal in nature, it will result in an examination of any unlawful acts that have been committed by individuals in Myanmar against the Rohingya and whether or not they might amount to genocide. Another legal innovation we've seen in the fight against impunity, the seeking of redress for victims, has been increased use of corporate accountability, civil, administrative and constitutional proceedings in different countries, where maybe criminal proceedings may not be available, but lawyers and victims groups are seeking redress through the civil, administrative and constitutional courts or through corporate accountability. I think the last comment I'll make is just to emphasize the importance of civil society and cooperation in international criminal justice. We're really seeing an upwards trend, a rise in multidisciplinary cooperation between the ICC, UN-created mechanisms, civil society around the world, and an increasing acknowledgement of the importance of civil society in cooperation across all these groups. So in summary, while we've seen great advances in international criminal justice since World War II, a number of challenges still remain and impunity still persists around the world. But in response, the international community continues to identify and implement new and progressive ways of seeking justice for victims.